Looking at their work, I'm seeing introduction. Okay. Good afternoon, gentlemen. So here we are again to continue our lecture on the law of evidence. So today I'm going to be looking at a topic assigned to group 7. And this topic says, is there a relationship between standard of proof and burden of proof? I have your work here with me, and I want to believe that every member of this group is present in class. To that effect, therefore, we adopt this paper as having been presented and demonstrated before the whole class. I'll just go through what you have done and then fill in the gaps. They talked about introduction. They talked about section 181 of the Evidence Act, what it provides. Then after that, they talked about burden of introducing evidence in civil cases, burden of introducing evidence in criminal cases, shifting of burden of proof, discharge of burden of proof by the prosecution, discharge of burden of proof in civil cases, and they also talked about standard of proof. I don't know why standard of proof should be the concluding part, but in the main, I've not seen any write-up addressing the question whether there is any relationship between standard of proof and burden of proof. But that be that as it may, so we'll just go ahead. I'm going to discuss the things I had expected this group to discuss in their work. Looking at it again, whether there is a relationship between standard of proof and burden of proof. Remember that yesterday we did talk about burden of proof, onus of proof, and we summed onus of proof into two perspectives. The first one being the general, ultimate, or legal burden of proof, which is on one side, and that's that proof, the burden of proof that lies on that party who will lose the case if no evidence is adduced from both sides of the divide. And then we also talked about the evidential burden of proof. The evidential burden of proof being those facts, those issues that arise within the trial where one person makes an assertion, a sort of claim, and when he makes that assertion, his opponent will do the best he can to thwart it. So the person raising this first issue is said to have the burden, the evidential burden, to discharge that allegation of fact that he has raised. And then the party on the other side who would also want to challenge it will also have to come up with his own facts to challenge the facts being adduced by the other party, so that in the end the court will have a holistic view of all the pieces of evidence placed before it. And then the court will begin to evaluate the evidence. In other words, to assess it, just like somebody who has written an exam. After writing the examination, your examiner will sit down, read your papers, and then compare it possibly with his marking scheme to see whether you have done well or not, and then mark your paper, and then in the end release your result. So this is something that can be akin to trial when we talk about trial in the court. Somebody who has onus of proof, both general, evidential, that have played out in a trial, in the end, the court will definitely have to decide to know whether these things said have been proved, whether the evidence adduced and placed before the court, whether those evidence are persuasive enough to make either of the parties win or lose, as the case may be. But then, when we talk about onus of proof, the next thing that follows onus of proof is the standard of proof. Standard of proof. We talk about onus simply meaning that responsibility that I have to show that I have a good case. My responsibilities maybe or include, let me put it this way, my responsibilities to show that I have a good case include for me to prove the elements, show the elements of my claim, and to do so persuasively, and also to do so by placing strong evidence before the court. Now, we've talked about the responsibility, duty, the onus or burden of proof. What about the standard? Standard simply means level. It's not just enough for you to come to court to give evidence. What is the class of evidence that is required of you? What is the strength of evidence required of you? What is that level of evidence that the court will require of you? Now, when you talk about standard, it simply means that there is a standard that a litigant must meet, especially this party that wants judgment to be entered in his favor. There is a standard of evidence that he must be able to meet with. So when he doesn't meet up with that very standard, it cannot be said that he has proved his case. He can only prove his case, or can be said to have proved his case, when he has succeeded in adducing that kind of quality of evidence that is required. I'm talking about quality of evidence here and now. It's not the same as quantity. The law is interested in quality, not quantity. And that's why the law doesn't require you to call a million witnesses. No particular number of witnesses are required to be called in any particular case. But you, as the master of your case, you should know how many witnesses that can come and give credible evidence, whose evidence will have quality, whose evidence will have that kind of standard that the court would listen to, assess it, and said, yes, I believe what so witnesses have said. That's talking about standard. Standard also is determined by the nature and the standard of quality of evidence adduced by your opponent. Where you have a case in court and your opponent fails to call any witness, that means that your opponent has not challenged your case. In that wise, the standard of proof required of you will just be minimal standard, minimal. So that's a standard, the minimal standard, just to show that something happened. Maybe you said Mr. A is owing me 10,000 naira. You have sued Mr. A for him to pay you your 10,000 naira. A refuses to come to court, or he comes to court and can't, just say anything, So in that end, the court will simply give you judgment once you can show there was a transaction between two of us, and in that transaction he became indebted to me. Right, that's the minimal standard. That thing that the court will hear you and believe that any reasonable human being hearing this will believe that this person is actually owing you. But look at another scenario whereby this man has come to court to say, I am not owing this man anything. I'm not owing him any 10,000 naira. He could maybe come to say that you supplied him goods and you gave him the impression that those goods were worth the sum of 10,000 naira. Particularly, he has bought these goods believing in the quality that you have represented to him, only for him to discover that the quality you are supposed to supply him was so substandard, not up to that very quality. And when it comes to court to say, this, what he supplied me was below the quality, it doesn't comply with the description, it doesn't comply with the quality we talked about. And this type of quality of material that is sold to me are materials that are sold for 3,000 naira, not 10,000 naira. You now discover that the dispute has really arisen and it has ripened. You are claiming 10,000 and he is saying no, it's 3,000. Why? Because what you supplied him was of low quality. The judge listening to you wants you to present, want to listen to see if you're going to present a higher level of evidence. If you're going to show a stronger evidence to show that what he is saying is incorrect. In other words, what we are talking about is that where a case is not defended or unchallenged, the standard required is simply that of minimal requirement, minimal standard of requirement. But where the case is fully contested in civil action, then it is said that the standard required is what? Proof on the balance of probabilities. You either call it proof on balance of probabilities, or you call it proof on preponderance of evidence. So these two things mean the same thing, but I'm also going to take time to split them, tell you what actually is the relationship between them, or what actually is the difference between them. Let's start by the first word that we talked about: proof on the balance of probabilities. Now, you are looking at balance. That balance is saying, it simply means that the court is not going to just depend on your own evidence. No, the court has to balance it. The court has to evaluate your evidence and the evidence of your opponent. That is the balance in there now. Probability simply means that what could be true, what can a reasonable man believe to be true in that very instance. You know, when you say that something is probable, it simply means that something has strong indication of being the truth. It may not be perfect, like I have said before. It's difficult to have a very perfect case. You may never have a perfect case. But the probability is something that favors one arm as against the other arm. So the court will look at this, look at the evidence placed before him, and then to see, having balanced it, which of this evidence appeals more to me, which of this evidence, if taken to the public domain, that reasonable people will come and say, I believe that this person is the person saying the truth. In other words, when you talk about balance of probabilities, you're simply having in mind that these people before you are not angels. They may not tell you the whole truth, or the whole truth may not come out the way you may see it, or better put, you may not going to see a case that has no fault. No. You're rather going to see this man's evidence put on one side, the other person's evidence put on one side, and then you as a judge will begin to consider it to know which of them is more believable, what more credible, which of them is stronger than the other. And I'm also going to tell you some of those things that the court takes into consideration when the court wants to find out the balancing, when the court starts to do the balancing of the probabilities. We first of all have to talk about the scale example. There's something called imaginary scale in our legal jurisprudence. The judge will, while evaluating this evidence, imagine that there is a scale. You know, when you have a scale, it's just like maybe you have like two buckets or two small pans, each of them having let's say a chain tying them to a particular strong stretch stick, so that one pan stays one side, the other pan stays at this side, and when they are empty, they are at the same level. Right. Now, when you take evidence of Mr. A and put into pan A, evidence of Mr. B, you put into pan B. By the time you finish sifting the evidence, the pieces of evidence placed before you as a judge, you will now notice that probably one of the pans will go down and the other one will come up, which means that the balance has tilted. There is no longer a level balance of the two pans. What has happened? What has happened is simple. That the pan by your left hand, the one that has drawn down, is carrying more weight than the pan that has been lifted up. In other words, the person who has adduced evidence that you have put in the pan that has gone down has adduced more evidence that are stronger, pieces of evidence that are stronger than the pieces of evidence put on the other pan that has been drawn up. That is the imaginary scale. And that's why we say that the judge has applied that rule, balance of probabilities. And when that balance of probabilities is applied, definitely one of the pans may go up, the other one will go down. There may be situations where both of them may still remain at the same level. But this very situation rarely occur. And it may occur where maybe A has not adduced enough evidence for him to be able to have the relief sought declared in his favor. And B also has not been able to actually traverse, impeach, and damage the cases of Mr. A. In which case you are looking at something like as if they are playing draw. Under some rules of court, the court can simply do what? Non-suit the other party. The court can simply non-suit the other party. All right. Now, I said that balance of probabilities is also equated with preponderance of evidence. Preponderance is just like what we have talked about. You pick from here, you pick from here, then you examine them. They mean the same thing. And this is the standard of proof required in every civil proceeding. And now, before I begin to tell you some of the elements that the judge may consider when trying to balance the probabilities of the evidence placed before him, we need to talk about the fact that in some civil cases, you may have a mixture of criminal allegation that is contained in that civil proceeding. Most of the times, you see things like this happening in election petition matters. Election petition matters are purely civil matters, right? It's a situation whereby Mr. A is saying, nullify the election of Mr. B because he did not score the majority of votes cast, or the election was marred by irregularities, electoral malpractices. And when you're talking about malpractices, electoral offenses, you are not talking about what? Crime. You are not bringing allegation of crime into it. Now, when in a civil suit, there is an admixture of a criminal allegation. What then is the standard of proof? In a situation like this, the rule of severance will be applied. Severance in the sense that those facts, those claims that deal directly and squarely on civil proceedings will be taken aside, and the standard applied to them will be what? Balance of probabilities or preponderance of evidence. But for that allegation of crime means that it must be done what? Prove beyond reasonable doubt. You must prove it beyond reasonable doubt. So I'm also going to look at some statutory provisions as well as some case laws. But then too, how would a judge know that the evidence of this person is tilting, is having more weight than the evidence of the opponent? Now, the first thing I want to ask yourself is, who has the onus of proof? That's the relationship now. The person who has the onus of proof takes the beating. What I mean by him taking the beating is that you are going to, first of all, place this onus on him to make sure that he has adduced all the elements that are required to prove his claim. And then the question now is, has he been able to plead those elements that will help him win his case? Has he been able to prove them? So those are the things the court will be looking at. Mind you that yesterday we gave an example of land matter and malicious prosecution. If, for instance, in a land matter, somebody just comes to say, declare me the owner of this land because I bought from Mr. A. And then all he has to tender is a power of attorney or even a certificate of occupancy, which he was able to procure after he has purchased the land. Let's say, for instance, the defendant or the other party in his evidence is able to show that one, the person who sold the land to Mr. A hadn't title in the first place. Remember, nemo dat quod non habet. You cannot give what you do not have. So the mere fact that this other person has come to court with a certificate of occupancy does not mean he must be the owner of the land. No, he must be able to show that the person who sold to him actually had the title to pass to him. So if in the end he's unable to show that the person who sold the land to him lacked the title to pass it to him, then that means that the standard of proof required of him has not been discharged. He has not been able to show that he is entitled to have the relief granted to him based on the balance of probabilities. Those elements must be there. That is the relationship between your onus of proof and your standard of proof, because as you are trying to discharge your onus of proof, they are mixed with the standard, and the standard of proof now is the quality of the evidence you are giving. Why? Because you may have a good case and still lose a good case because of your presentation. If you have a case and you know that you have the onus of proof. First of all, let's just talk about the land matter that you bought from somebody. You need to know who sold to that person. You need to also to be sure that the person who sold to your predecessor in title also had the title to pass on to him. Now, when all these facts are placed before the court and you have successfully pleaded them, then you now begin to look for what I can call now the proper witnesses. The proper witnesses. There is a proper witness that If the witness is not there, whatever you're saying may have loophole. You may have difficulty proving your case. So your onus of proof will help you to build up your standard of proof. The standard required is now where you're going to choose. Am I going to this one? Did he give me any document? Good. Documentary evidence. I pick my documentary evidence. Right. And when I pick my document, which I am going to tender, I need to also ask myself, what type of document am I holding? I have a good case, quite all right. I bought the land, good. Now, what if I maybe go to court with a photocopy of a document, just tender it, and in the end it is rejected and marked rejected? I have shot myself on my leg. What has gone wrong? I knew I had the onus of proof, and part of my onus is to tender document. I have brought the document, but I have done it wrongly. That is standard. So in that standard now, I ought to have looked at this. So if it's a public document and I have original copy of the public document, all well and good, I will tender it. But if I don't have it, what do? I go for a certified true copy of that very document. Why? Because we are talking about what? Standard. And when I'm choosing my witnesses, I need to have my direct witnesses. Witnesses, assuming is something that has to do with, let's say, the land also. My boundary neighbor. My boundary neighbor, I will call my boundary neighbor to come and testify and say that, yes, the person who sold this land to me, they know the person, they have been farming alongside this person for many years. And then this person who sold to me also will have to be called to give evidence, except maybe he's unavailable and I have that document, which is also a direct evidence that I can do what I can rely on. That's talking about standard. In other words, the standard here is that whatever evidence I'm giving must be what? Must be credible. It must be strong. So I'm trying to labor to ensure that I'm using evidence that is stronger than the evidence of my opponent. So if my evidence is not stronger than the evidence of my opponent, when the court starts to balance the probabilities, the court will ascribe more weight to the case of my opponent than my own case. But when I have credible and strong evidence, I can then be sure that I am on the line of satisfying the court that I am entitled to the relief sought based on what? The credible evidence that I have been able to present. So we'll look at some of these authorities. So I want to cite first of all, before this, I did mention that in a civil matter, where a civil matter has a criminal element to be proved, you have to prove it beyond reasonable doubt. For that, you look at section 135, subsection 1, section 135, subsection 1 of the Evidence Act. It says, if the commission of a crime by a party to any proceeding is directly in issue in any proceeding in civil or criminal, I can cancel criminal now because I'm concerned with civil, it must be proved beyond reasonable doubt. So section 135 subsection 1 of the Evidence Act is saying, in any civil matter, if there is an allegation of crime, my onus does not stop on the proof of the civil aspect. No, I must be able to do what? Also prove that criminal allegation of fact. And how do I do that? What is the standard? My standard is what? Prove beyond reasonable doubt. For that, see the case of Mehaja Maihaja is spelled Maihaja, against Gaidam. Gaidam spelled Gaidam. Reported 2018 for Nigerian Criminal Law Report, at 1610, page 454. Page 454. All right. And then, still on this proof that we are talking about now, let's also look at some case studies. In the case of Triversal Design Associates, I will spell that. Triversal is spelled Trioversal. Triversal Design Associates against the Commissioner for Health and Human Services. Commissioner for Health and Human Services, Yobe State. Commissioner for Health and Human Services, Yobe State. This case is reported 2020 for Nigerian Criminal Law Report, part 1714, at page 243. At page 243. So I'm interested in what the Court of Appeal said at page 275 of their decision. Yeah, the Court of Appeal said civil cases are won upon a preponderance of evidence. I repeat that again. Civil cases are won upon a preponderance of evidence. Therefore, the claimant in a civil case has the burden of establishing his claim upon relevant and credible evidence that is conclusive and commands such probability that is in keeping with the surrounding circumstances of the case at hand. And applying it to this case that I have cited, the Court of Appeal said, in this case, the appellant did not lead sufficient evidence to discharge the onus of proof on it. The appellant did not adduce sufficient evidence to discharge the onus of proof on it. I recommend that you read this case and find out why the appellant at the lower court could not be able to satisfy that standard of proof that was required of him. So try to read the facts of that very case. So we can also look at some other cases that still touches on that. And before going over to the other side of standard of proof, because your question is all encompassing, it's telling you to discuss the relationship between the onus of proof and standard of proof. That means both in civil and criminal proceedings. Now, other thing that the court will consider when we talk about standard of proof, whether this person who has appeared before the court, whether the person has actually proved his case. First of all, like I have said, look at the kind of case the person is presenting. Has he been able to prove the elements of that case? When we look at the evidence that he has presented holistically, are they self-conflicting? If your witnesses testify and they show fundamental contradictions of themselves in their evidence, then you have a problem. Once there is such fundamental contradictions in the evidence of your witnesses, it simply means that they are doing what? They are drawing your standard of proof down, not down by way of weight, but they are destroying it. That's why you also need to know when your witness is a hostile witness and you apply to treat your witness as such. That is also why you need to have intelligent and smart witnesses, witnesses that are sharp in cognition. You ask them questions, they are able to do that, they are able to answer. And then again, apart from looking at your kind of case, also try to look at the requirements of law. What has the law required of you in your case? All those things will come to play when the court starts to consider your standard of proof. If you are doing a matter where you are required to have a corroborative evidence and you fail to do that, that is a big minus to your case. So that's talking about standard of proof. Standard of proof. So you just must have to sit down, ask yourself, what are these onus? What am I supposed to discharge as onus? And then how do I go about them? The how is what is the standard. So how I'm able to do it by selecting cerebral witnesses, selecting my best of evidence. We are not talking about that you're going to cook up your stories, because one thing is easy to lie, but very difficult to defend your lies. So if you are sure of your case, and in this our present world, safety your witnesses. Don't go to take that witness that if they give him a semen aromatic schnapp, he changes his story. So that's also talking about standard. Right. So what I've been able to look at the relationship between onus of proof and standard of proof in civil matters. They go together. Right. And the standard is the business of the court. It is the court that looks at that your standard. That standard is the marking scheme with which the court marks your case. Whether you have discharged your onus satisfactorily, creditably, and whether they are strong enough for the court to believe and say, yes, I believe this person. I am satisfied from the evidence before me that the claimant has proved his case as required by law. I hereby enter judgment in favor of the claimant as claimed. That's the business of court. Then let's look at the other way around, talking about standard of proof in criminal proceedings. But we first of all have to look at the onus. Why? Because we are trying to draw a comparison here. We are trying to see if we can marry them together, if there's a relationship between two of them. Onus of proof, the burden of proof, the general burden of proof, like I said, also applies in criminal proceedings, but it does not shift. It does not depend on who will lose. Quite unlike civil case, in civil proceedings, where the law is that the onus of proof will lie on that party who will lose if none of the parties adduce any evidence at the trial. But in criminal prosecution, the general burden, ultimate burden, legal burden of proof rests squarely on who? The prosecution. Why is this? It's because when you are talking about criminal trial, you are putting somebody's liberty at stake. Somebody is standing trial. He might have committed the offense. He might not have committed the offense. And that's why the Constitution says, do what? Presume him innocent until the contrary is done what? Is proved. So the onus of trying to thwart that constitutional privilege, that constitutional right, which is rebuttable anywhere, lies on